Hello everyone, welcome back to the channel. I hope you all are doing well. Today's video is going to be very important and very relevant, especially for those of you who are navigating the US immigration system or waiting in green card backlog for a very long time. So there has been a lot of discussion, confusion and speculation recently, so I wanted to bring in a qualified immigration attorney to help us understand things clearly and correctly. I'm very happy to welcome Gabriela from Manifest Law. So Manifest Law is a US-based immigration law firm that many of you already know, and they have worked extensively on employment-based and family-based immigration matters. Gabriela, thank you so much for joining in today. Before we jump into questions, I'll let you briefly introduce yourself and tell our audience a little about your background and the work you do at Manifest Law.
Sure, thank you so much for having me. My name is Gabriela Urizar, and I'm an immigration attorney at Manifest Law. I have almost a decade of experience practicing as an immigration attorney, and throughout my career, I have specialized in work visas, business immigration, student visas, and advising some of the largest corporations in IT, banking, and architecture in the world.
Thank you, Gabriela. For everyone watching, just a quick note before we continue. If you have any immigration related needs, whether it's visas, green cards, employer filing, or long-term planning, I recommend checking out Manifest Law. I've added their link in the video description, and you should also see a QR code somewhere on the screen right now that will take you directly to them. So as always, this conversation is meant to provide general information for clarity. For advice specific to your situation, it's always best to consult an immigration attorney directly. With that said, let's get started with the questions. Okay, so Gabriela, we have been hearing that since January 1, a travel ban is in place for 39 countries. And in simple terms, what is this ban really about and who does it actually affect?
So I think it's important to understand that there are two parts of this ban, right? So what people are calling the 39 country ban is really a proclamation by the president and a USCIS memo that just came out on January 1st. So let's talk about the presidential proclamation. So the presidential proclamation suspends or limits visa issuing and entry into the United States for certain foreign nationals based on national security or vetting concerns, right? So it mainly affects people who are outside of the United States and do not have a visa yet to enter the US, including immigrant visas. And this is the most controversial part because usually green cards based on family, like married to a US citizen or green card holder, are usually exempt in this type of applications or bans. But in this one, it includes also immigrant visas. So they're also included. So if you were born in one of these countries and don't have a visa yet, by the time the proclamation went into effect, you are not able to come into the US or get a new visa. So the State Department has been very explicit about the proclamation that it generally applies to people who are outside, right? And that they do not have a visa stamp. Now, the second part of the ban is the USCIS memo that came out on January 1st of this year. And basically, the memo expands what the proclamation had already put into place. So the proclamation also puts on hold or pause applications for people that are inside of the United States. So this means that if someone who is from the list of the countries is already living in the United States and files for an immigration benefit like a green card or a work permit, an extension, a change of status, then USCIS has to put a hold on the case. They cannot issue a determination on the case. This doesn't mean that the case is being denied. This just means that there is a pause, that they cannot provide you an answer.
Okay, that makes sense. Thank you. So looking at this from a green card angle, if people from those countries can't use their visas because of this ban, what happens to those green cards? Do they just go unused or are they reassigned?
So if we're talking about immigrant visas that are issued abroad at the consulate, the green card really is an immigrant visa number, right, for that fiscal year. As we know, the Department of State every month puts forth a visa bulletin which shows the availability of visa numbers, green cards, for each category. So if a person cannot use the immigrant visa or cannot enter the United States because of the proclamation, the visa number can end up being not used for that fiscal year. So what happened to all those numbers that are not being used, especially for the family-based applications? Those numbers that are not used get into a process called a spillover. So they don't typically, let's say, get handed out to a specific group of people or from certain countries, right? Instead, what matters is how the law handles these unused numbers at the end of the fiscal year. We know that the fiscal year starts in October, especially for the family sponsor preference categories, not the immediate relatives. This is very important to point out. So this leads into something that's called the spillover, which gets pretty interesting because the visa numbers that are not used for the family-based categories then get divided between the employment-based categories.
Okay, so you said two things. One is like family-based and employment-based. So can you walk us through how family-based and employment-based green card quotas work and how they are different and how many green cards go to each category and what happens, like you said, like if a green card is not used in family-based, it just spills over. So is it like how often does this happen?
So it usually happens when we see a situation like what we're going through right now, where there's a administration saying through proclamations, executive orders, or memos that a large number of people that qualify to get a visa number cannot enter the U.S. So they're likely not going to be able to use those visa numbers. Now let's take a look into the different categories. We have family-based, and then we have the employment-based. So for family-based, we have the immediate relatives of U.S. citizens, which are the spouses, unmarried children under 21, and the parents of U.S. citizens. They are not subject to the visa numbers, right? So they don't have to wait. They can just come into the United States. Now, for the family sponsor preference categories, which are subject to the visa cap numbers, are the F1 category through the F4, and these are limited. You cannot get more visas in these categories more than what it is being allocated under the visa bulletin. Now, under that, we have the employment-based visas. And employment-based immigrant visas are also numerically limited each year, each fiscal year, and they are divided between 5 categories: EB-1, EB-2, EB-3, EB-4, and EB-5.
EB-5.
And they're actually fixed by percentages. So every year, Congress allocates a percentage depending on the category, right? And we'll talk more about the percentages. But now, this is where the spillover concept that I was talking about comes into place. So under the statute, numbers that are not used under the family sponsor category from one fiscal year are there added to the pool that are going to be allocated for next year for employment-based categories. So this is what it's called the spillover. So within the employment-based categories, if a higher preference doesn't use all of its numbers, then those numbers can fall down to the next category and so forth.
Okay, so does this happen automatically or there should be any government intervention behind the scene to spill over from family to employment based?
So this doesn't happen automatically. It all depends on the operations of the government, right? Like the USCIS. So the concept of the spillover is already built into the statute. So USCIS doesn't have to vote on it. If a family sponsor preference numbers go unused, the law provides that they get to be added to the next year. So let's think about what does that mean in the real world. So that depends on operations, like I said, right? Whether visas actually go unused, like if they're not used, whether agencies like USCIS can process enough cases to use all those available numbers, and the timing within the year.
Okay. So there's a lot of discussion among Indian green card applicants that this situation could help them move forward in green card queue. Is that a realistic possibility?
So if the proclamation and the enhanced screening reduces the number of family-sponsored preference visas and we have a large number that's not used, likely this could right, increase the total for employment-based categories for next year, and for countries with really high demands and long backlogs like India, this could result in a benefit because more numbers will likely be allocated for the categories that have a huge backlog. And as we know, since there is such a big need of visas for Indian-born nationals in the EB-2 and EB-3 categories, we likely will see a movement if they're able to get extra visas that were not used from the family-based categories.
Okay, so maybe this question is little more, based on my research, around 12 to 14% of total green cards in 2023, roughly around 150K, were issued to these applicants from the 39 countries which has been banned. So is there any like realistic formula or something which we can calculate to find out like how much it would get to Indian nationals who are waiting for so long in backlog?
So this isn't a simple country, X or India gets a percentage, right? Like what happens in practice is that the numbers that are not used from the family sponsor preference then increase the worldwide employment-based limits for the next year. So then those employment-based numbers are allocated across the EB-5 categories by statute. So for example, EB-1 category, EB-1-2, EB-3 get about 28.6% each. EB-4 gets about 7%, and EB-5 gets about 7%. So then the last step is that then the per country limit constraints apply, right? And numbers are issued in priority date order. So the key point is that the spillover increases the worldwide pool, not specific to each country.
Okay, so let's assume, so if this continues for rest of this administration, like we have a presidential proclamation, so let's assume that if this continues for rest of this administration, many people believe that this ongoing spillover could benefit Indian green card holders. And from your statement, I think that is a fair assumption. Do you agree on that?
It is a plausible assumption, I agree with you, but that's not something that I will say that it's for sure a guarantee, right? And why is this? Well, because the spillover depends on whether visas are actually not used at the end of the year, right? So over time, agencies sometimes adapt case shift policies for adjustment of status inside the United States. We don't know the percentage of this number that you reach that are going to obtain exceptions, or they're going to qualify for a national interest waiver to be able to come in. We don't know if litigation is going to make any changes, or if consular operations are going to shift. So there are a lot of unknown factors. Also, the USCIS memo makes it clear that this hold stays until it's lifted or modified by USCIS leadership. So it can slow approvals for affected applicants inside the United States, but we don't know how long the delays are going to happen, right? Because we still have a few more months, well, most of the year to end the fiscal year. So a lot of things can happen before that. So it is a plausible explanation. It could create a spillover that could probably benefit countries that have a backlog like India, but to the extent of whether that large number that you provided me with will be then given to all the categories, we don't know that for sure, because we don't know how many people will actually be able to get a green card, either to an exception, application, what are the operational capacities of USCIS. So a lot of factors, but definitely something that makes sense and that could happen, and that has likely happened in the past, where we see a spillover, and then we see people from countries that have a backlog benefit, and then we see movement in that particular country and category.
Okay, that makes sense. So I know that spillover green cards don't go to just one employment category and have to be allocated across all EB categories. And I think the EB-1 benefits the most, and then it just rest of the categories. So Is it a true statement that like the EB1 category would benefit more, and if there are anyone who's waiting in EB1A would get faster than rest of the categories?
So that depends on the country of birth, right? Because I think currently the visa bulletin for EB1 for other countries, I think it's current, so they don't really have a waiting time. But if you're born in India or China or another country that has a backlog, then you could really see a benefit because EB1 will likely be the first one that gets the spillover visas. And then by statute, the employment-based categories have the following fixed percentages. EB1 has 28.6%, EB2 has 28.6%, EB3 has 28.6%, EB4 and EB5 have about 7.1%. So in practice, the biggest movement that people could likely see, yes, it could be within EB1 for people that have a backlog, but it also could affect people in EB2 and EB3 categories because those categories also have huge backlogs for India and China. So added numbers will get used very quickly, which will likely lead to a movement on the priority dates for the visa bulletin.
Okay, so because EB1A usually moves faster, many people in EB2 or EB3 wonder if they can move to EB1A. What does the process look like and who realistically qualifies for that?
That's a really good question and a question that I get asked a lot, but it's not as simple as it sounds, right? So EB1A is the category for people who fall into the extraordinary ability green card. So it's not a transfer, like you can really transfer your current case and, upgrade it to EB1, like we see people doing sometimes between EB2 and EB3. So for the EB1, you are essentially filing a new I-140 under the EB1A category, and if you later file or already filed an I-485, then you might be able to interfile or transfer the basis of the adjustment of status to the EB1A approval. Who qualifies for this type of visa? USCIS describe this visa for people who are at the very top of their field and that they have sustained a claim. So typically in terms of requirements, you have two options to get this visa. The first option is to either win one major internationally recognized award like a Grammy, Emmy, Tony, Pulitzer, Nobel, or if you don't have one of those awards, you can show evidence that you meet at least 3 out of the 10 regulatory criteria that USCIS has, right? And then USCIS applies the final merit analysis to see that if you really have established the argument that you have positioned yourself at the top of your field. So realistically, strong EB1A candidates often have a combination of awards, high impact publications, leading roles, they have judged the work of others, they're being asked to speak on conferences, they have done contributions to their industry like filing patents or creating a type of software. They usually have a higher salary compared to their peers. So it is very evidence heavy and not everyone can fit into the EB2 or EB3 category. Yes, so I do have 2 last points that I want people to remember. The first one is for people to understand that a travel ban is not all immigration stops, right? The proclamation mainly hits the visa issuance and the entry into the United States for people who are outside the United States and don't have a visa. While the USCIS memo is something different, which is putting the applications for people from this country on hold. Doesn't mean a denial, it's on hold. Then the last thing that I want people to remember is that family-based immigrant visa cases are now explicitly subject to heightened scrutiny under this framework. So USCIS notes that family-based immigrant visas are no longer automatically or broadly exempt from these restrictions, which, like I said, is something that we've seen in past travel bans or proclamations where they specifically list an exceptions for people who are immediate family members of either U.S. citizens or legal permanent residents. We don't see that here.
That makes sense. Thank you. So I have one last question. This is not related to this travel ban. It's a different topic. The famous one, like the presidential proclamation where it says like for new H-1B, which was file outside from USA, they have to pay 100,000 fees first. So there is a small rumor and like some concern going on in the many forums that like if you are changing from H4 to H1 when you are inside the US, so will that also fit this proclamation, or they are exempt from this 100,000 fees if they are trying to change their status from H4 to H1 this season?
So it is important. So yes. So when the president and this administration put forth the $100,000 fee new rule, there was a lot of confusion and there wasn't a lot of clarity. But based on the last guidance that USCIS has provided, this fee will likely not apply for someone in this situation because it's not applying for people who are inside the United States and filing for either change of status, which in this case it will be from H4 to H1B, or change of employer, or extension, or amendment. It doesn't apply in this situation. It applies when the person is outside of the United States, doesn't have a visa, and is filing for a new H1B, which requires consular processing. Where it can apply to someone that's inside the US is if someone files for a change of status, and for some reason USCIS approves the new H1B but denies the change of status or the extension of status, and requires the foreign national to activate the H1B at a consular abroad. Where I've seen in practice where this happens is when people have issues either with maintaining lawful status. For example, they work or they did some type of work that they were not supposed to do, or they overstayed in the US, let's say a day or two or a few days after their I-94 expired. So USCIS sends them abroad just to clean that entry. That's where I've seen it to happen in practice. But if someone who is transferring, changing of status from H4 to H1B, has no issues with maintaining lawful status, has no prior arrest, the application is clean and straightforward, very, very unlikely that this fee will apply. So I don't think it will apply.
Okay, and just to make sure that if someone applies for change of status and if they leave the US, then probably like they're abandoning the change of status and like that would convert into the consular processing. Is that a true statement?
Yes, I'm very surprised that you know that because a lot of people miss the point. No, I'm very, very impressed. Come work with us because a lot of people miss the point that when you're inside the United States and you file for a new H1B, you're applying for two things. You're applying for extension of status and you're applying for a new H1B, right? So if you depart the United States before your H1B gets adjudicated or approved, the change of status part of it will get denied. They can't extend your status of change your status if you're not physically in the US. Like, what are they extending, right? They could approve the H1B. Like, they could say, yeah, sure, we'll give you a new H1B for 3 more years, but you have to activate it abroad. So my recommendation is, if you're filing for an H1B, stay grounded in the US until you have that approval, or else USCIS will very likely issue that approval with consular processing, and the fee will likely apply.
Okay, so one last question, Gabriela. So we know that there has been like a heightened social media vetting, right? So do we have any cases, like whether you or in your law firm, that have been affected by this like vetting and then they have to do some process work? Do we see a pattern or any clarity on what they're actually doing behind there? Are they checking everything? Are they using AI to check? Do you have any information on that?
I think that's the most frustrating part, that there is not a lot of guidance in terms of specifically what the government is looking for in terms of precluding people from coming because of the social media vetting. And something that I like to remind my clients is that keep in mind, right, that Indian H-1B holders or H-4 holders, most of the time they're highly educated. They're very sophisticated, right? They work for very important companies. It is very unlikely that an H-1B holder with engineering degree or computer science working for a very renowned organization is going to have controversial things on their social media. It just doesn't align with their professional profile and the type of education that they have. So it's very unlikely. even within the firm, but also I have a huge network of friends and colleagues that practice immigration. I have not heard of anyone that had a client had their visa denied because the government found something that it didn't pass the social media vetting.
That's all, Gabriela. Thank you so much for all this insight. It was really good discussion, and I'm really happy to host you. Thank you so much.
Thank you for having me. I had so much fun.